Okay, welcome back to Fraudclosure 101. Hopefully you've enjoyed the rest of the videos on our YouTube channel, but this, among the other videos, aside from the introduction, is probably the second most important one. This video, what is a complaint? If you're watching this, you either have been served or you will be served if you're a homeowner in foreclosure with this document called a complaint. It comes with a summons. There's a separate discussion on the summons we could have. Basically, we'll just summarize it as a document that commands you to file an appearance or attempt to do something and give you notice that a suit is commenced, and it gives the address of the parties. And in Connecticut, you get all sorts of other forms like the application to intermediation, notice of rights if you're unemployed or underemployed, and so on and so forth. So the summons for that, for our purposes here, is just self-explanatory, and we're going to leave that aside. Our question, what is a complaint? Now, you obviously have some idea if you're a homeowner, you've been served. Obviously, you know the complaint is the first document in the case that the bank has filed, and they're looking to take your home. Now, fundamentally, it doesn't matter what type of legal action you're talking about, a complaint is a set of facts that the plaintiff is alleging. It's not proven, it's just what the plaintiff alleges and would intend to improve that would support a cause of action. The complaint also defines what the plaintiff is looking to recover. What I did here to make it easier for our purposes, I wrote just a sample generic complaint, 5 paragraphs, just right to the point. You know, and this is a hypothetical. Paragraph 1, the plaintiff is X, could be a corporation, person, whatever, resides at Q address, wherever. Paragraph 2, that triangle, that's actually the symbol for defendant, so, you know, just so you know, that's just the short version. It says defendant is Y at A address, okay? Paragraph 3, the parties had contract to do E, F, and G, whatever that may be. Paragraph 4, the defendant did not perform / pay or whatever the case may be. Paragraph 5, plaintiff is damaged and the plaintiff could fill in X whatever. Wherefore, and you'll notice this if you've been served with a complaint, wherefore at the bottom it will say, the plaintiff is asking award plaintiff X dollars and order the defendant to do N, P, or Z, or order whatever relief they're looking for. Simple and to the point, okay? And a lot of people see a complaint and they have a lot of assumptions that, quite frankly, aren't true. Now let's go through some of those assumptions. Basically, a complaint is not evidence, okay? That can't be evident, that can't be emphasized enough. A complaint is not evidence at all, period. Just because somebody makes an allegation, just because somebody says, you do this, just because somebody wrote it down, okay, that's not evidence. That's basically, again, what the plaintiff intends to prove to support their cause of action. Now, whether or not there are certain facts in there that should be in there or should not be in there, that's kind of a discussion for other responsive pleadings to a complaint. But the bottom line is the complaint is the first pleading that starts the entire case. That is the foundation of what goes on going forward. Okay? Needless to say, a plaintiff is also not necessarily an offer of proof. No plaintiff has to include a copy of the contract or whatever, although sometimes they do, just to kind of speed things along. But fundamentally, a complaint is not an offer of proof. Again, all it says is the plaintiff comes into court, the plaintiff says in their complaint, here's what I intend to prove, and when I prove that, I want whatever it is I'm asking. Okay, and finally, a complaint is not testimony. That also can't be emphasized enough. It's not under oath. It's not, evidence in the record. All it does is says the plaintiff intends to prove all this, and when they prove all this, they're going to say, I'm entitled to this relief down here. It's pretty straight. It's very simple. It's to the point. And from a homeowner's perspective, that's really how you should understand it. In other words, the complaint is not the end. It's actually the very beginning. A lot of homeowners have this misconception that once they've been served with this complaint, they have to leave. They have to get out. And that's not true. Because when you've been served a complaint, judgment clearly has not been entered. That's just the beginning of the case. A lot of times, what I've found as a paralegal, and a lot of attorneys I've worked with have found the same thing, is sometimes the plaintiff leaves certain things out, or even better, the plaintiff makes certain allegations that actually are favorable to you, or in the case of suing the wrong person, that could also be favorable. So one thing you have to bear in mind, and this is actually kind of a minor point, but maybe you might run into it, maybe you might see something where it's good to look at it from this point, but one thing you have to remember is litigants in Connecticut are bound to their judicial admissions and allegations, because Connecticut is considered what's called a fact-pleading state. In other words, if the plaintiff walks into court and says, the note and the mortgage were assigned to X person or X party, and as a matter of fact, that ends up helping you like sometime down the road because another bank wants to come along and say, well, we own the mortgage or whatever, that could be an interesting situation. So again, the bottom line with a complaint, just to keep this very simple, all it is a set of facts that the plaintiff is alleging that they're arguing would tend to support their cause of action. Now, speaking of argument, and this is something important to bear in mind when it does come time to file an answer or special defense, pleadings are never specifically arguments in any sense or in any context. I've seen a lot of people that are self-representative, and even a lot of attorneys will do this. They, instead of alleging a fact, will actually start to make an argument. They'll say, well, this law says this other party should do this. Or in the case of a self-represented party, I've seen cases where the plaintiff will file an answer that says, well, this is denied because of this, or the plaintiff shouldn't have this because of this, or whatever. The bottom line is, complaint is not only a pleading, but it's the first pleading, and it defines the ground rules. It defines the issues that the plaintiff is going to prove, and is going to cover in discovery, and is going to offer up to the court to say, this is what I'm going to prove, and when I prove it, that is what's going to entitle us to take your home. And it's pretty simple, and I think a lot, especially from my experience, I've noticed a lot of pro ses look at this, particular document, the complaint, really in such an intimidating light, and they kind of overvalue it to an extent, and they freeze up, and they really ought not to. So the bottom line is, if there's anything that should make you feel better when you've just been served a complaint, all it is a set of allegations, and it's nothing more until the plaintiff comes to court and offers proof, and the procedures go from there. Hopefully that explanation was helpful. And as a side note, before we end this video, I can't emphasize enough that a lot of people just get fixated on this, and they go so much into panic mode that they even go beyond that point where they don't even ask, what is a complaint? And that really should be the first question, because understood the way it should be, that a complaint is a set of facts that allege would support a cause of action and define what the plaintiff is looking for, that should give more comfort than it does in most cases. Okay. That said, if there's any questions, comments, send your email to headlinecopy@gmail.com. Please look at our other videos, and hopefully we've helped you. And again, stay in touch, and hopefully there's something we can do for you.